All right, it is 9:30, so we're going to go ahead and get started, everyone. Thank you for joining us today for our kickoff of the summer for a legal update. We're joined by John Gilbert from Sandberg Phoenix. They are a law firm out of Edwardsville where they focus on labor and employment law. And John has been with us a few times now to bring us some legal updates. So as we're heading into the summer months, we know June and July can bring some changes to some employment law, and I'm excited to see what he has for us today. Now, this is a new platform that we have switched to. I'm going to try to spotlight John so that he can potentially have the full screen here and not just a smaller box. We'll see how that works. There's also a chat and some Q&A. If you'd like to throw those questions in there, I'll be sure to get those over to John so we can get those questions answered. All right. So, John, I will let you take it from here.
Great. Thank you, Summer, and good morning, everyone. Thank you for joining us. We regularly conduct programs on behalf of Higher Level, which is a fantastic company, as most of you, I hope, already know. Usually in the spring or early summer and in the fall. And this year, well, first I have to tell you a couple of disclaimers. This presentation should not be considered to be legal advice. If you need legal advice, please consult your legal counsel. If it's labor and employment law, of course, feel free to consult me. But I ethically, I have to tell you that this is not legal advice. It's informational. And thank you all for joining us. As you might imagine, there's a lot to talk about. Since the election last fall, many things have changed on the federal level and many issues are still unresolved. As you know, from just even a casual glance at the media, things are unstable on the federal level with respect to many legal issues that we face as HR professionals and as labor and employment attorneys. And I'm going to talk about some of those today, as well as some of the other initiatives going on in the federal government, state government, and particularly in Illinois. But I have chosen topics that are somewhat universal across the country. Not every state has adopted the statutes I'm going to talk about, but there's a trend. I've picked up on some trends and we'll use Illinois law to illustrate those. So, and as Summer said, if you have questions, please put them in the chat and we'll try to get to those. Usually this hour goes so fast that sometimes we don't have time. So I'm going to get started. And what I want to kick off with is what's going on with the Equal Employment Opportunity Commission, the EEOC. There's a lot going on. There's a split among the commissioners, and the acting chair, who is a Trump appointee, is at odds with some of the other commissioners with regard to some of the activities that EEOC is pursuing this year. But here's one that's not really controversial, and that is the EEOC's initiative with regarding artificial intelligence. There has long been a concern at both state and federal levels with regard to the use of AI in the selection process. And those of you who are HR professionals know that there are big concerns about the use of AI because of its possibility of built-in biases. So on the federal level and state level, actions have been taken legislatively and in the regulatory process to try to make sure that the use of AI tools, especially in the selection process, is not discriminatory. And the EEOC is at the forefront of this. You can go on its website and you can see all the initiatives and the details and the regulations and the concerns that EEOC has with regard to the use of AI in the selection process, especially. And the primary focus is to be sure that artificial intelligence, which is very efficient in the selection process, my clients love it, but there's a concern about bias. And legally, AI must not be used in the selection process or in any other employment decision if it has the effect of discriminating against anyone, any prohibited bases, I should say, whether it's race, sex, religion, national origin, the whole panoply of protected categories. And we'll talk pregnancy included. We'll talk about that in a few minutes when I discuss the Pregnant Workers Protection Act and the controversy that's swirling around that at the federal level right now. But suffice it to say, at this point, you need to be cognizant of and pay attention to the regulations and guidelines coming out of the EEOC with regard to the use of artificial intelligence. I'll come back to this issue because Illinois and other states have also jumped on the bandwagon to protect employees with regard to the use of AI in the employment process, especially selection. Excuse me. It will be no surprise to you that the EEOC's involvement with regard to DEI, diversity, equity, and inclusion, is at the forefront of the consequences of President Trump's executive orders addressing DEI. Where this has surfaced lately at the EEOC is in a couple of ways. One is, as all of you probably are aware, the DEI executive order and how it's being implemented throughout the federal government is under challenge in federal court. Various courts at various levels. Ultimately, it will reach the Supreme Court and will have a definitive decision from the court, perhaps. So where I have seen it lately and where it is garnering attention right now are in two areas. One is the harassment guidelines that were issued by the EEOC prior to the Trump administration. Those harassment guidelines included protection. And we're talking about harassment under Title VII and the other statutes administered by the EEOC. A couple of the more controversial harassment guidelines issued by the Biden administration were the use of bathrooms and pronouns. The Biden administration regulations provided that the misgendering, if you will, of people, as well as restrictions on bathroom use, constituted harassment. Well, the Trump members of the commission disagree with that, especially the acting chairwoman. And yesterday, a federal court in Texas vacated those provisions of the harassment guidelines. So we're off to the races with regard to court battles, with regard to the harassment guidelines issued by the EEOC during the Biden administration. So we'll see how that plays out. So that's one area right now where there's controversy and where the DEI issues have and the gender ideology issues have become the forefront of legal battles. So we'll see how that plays out. It's going to take time. Another area where we have seen the impact of the DEI executive order is yesterday's announcement about EEO1s. As all of you know, if you're a large enough company, you have to file an EEO1, which details your workforce, breaks it down in categories required by the EEOC. And in yesterday's announcement, the chair of the commission indicated and reminded employers that, as she put it, there is no DEI exception to Title VII, and reminded all employers that the EEO1 needs to be completed by the end of the month, I believe, with that in mind. And the EEOC has released a couple of guidelines and some press releases to remind employers that in the enforcement of Title VII, the EEOC's position, consistent with Trump's executive orders, is that there is no DEI exception to Title VII, so that actions and reports and policies of employers that are covered by Title VII must reflect that policy. And so, as well as EEOC is encouraging those who believe they have been discriminated related to DEI to file charges just like anybody else who believes they have been discriminated against would file, because they've taken a hard line that any type of discrimination prevented by or prohibited by Title VII is illegal. And that includes, of course, any type of race discrimination or any decisions, any employment decisions made on the basis of race. So this is a new day for the EEOC and for those of us who practice labor and employment law, and for those of you who have to navigate these very difficult and challenging regulatory and legal issues, especially arising out of an executive order and its implementation that isn't very old, and which is constantly under legal challenge. So I do not envy employers right now, especially HR professionals who already have the hardest job. This is going to be difficult. So you need to work hand in hand with your legal counsel, stay on top of government regulations, legal cases, to make sure that you can manage these issues as they arise. It's a big deal. Along with these issues, of course, the EEOC continues to enforce Title VII. And there's, if you go to the website or you get involved in cases of your own, you'll see that the normal functioning of the commission is going on. They're filing lawsuits, they're processing charges, and there is some level of normalcy. But these new challenges arising out of the new administration are presenting obstacles and, as I indicated, challenges that we have to navigate. Another area that has stirred up a little controversy is the Pregnant Workers Protection Act. This is a piece of legislation that's a couple of years old now that is designed to protect pregnant employees, and in fact adds an element of affirmative action, if you will, with regard to pregnant employees. And I don't think anybody disagrees with the goals and the purposes and the provisions of the act. The controversy has come in with the regulations that were issued by the EEOC. On April 3rd, not that long ago, the acting chair, the now acting chair, Andrea Lucas, who was appointed by President Trump, issued a statement objecting to the final regulations that were adopted by the commission and seeking to vote on them again. The controversy that arose, at least with her, is the belief, and also the legal challenges have been made against these regulations, which are pending in more than one federal court. The complaint is that the regulations went beyond protecting pregnant workers. And I don't want to get into the weeds on this because we don't have time, but her major complaint, and the major complaint in these lawsuits, is that the regulations sought to regulate more than just pregnancy in the workplace, that they went beyond to require accommodations ranging from infertility to menstruation to hormone issues to menopause, and as well as she puts it, current pregnancy, past pregnancy, potential or intended pregnancy, infertility, fertility treatment, etc. So her complaint was, in the lawsuits that have been filed to stop these regulations, or the breadth of the regulations, all maintain that the EEOC is over-regulating in its zeal to enact public policy. So we'll see how that goes. The legal challenges, of course, are pending, as they are on just about everything President Trump has done. So you have to really pay attention to what's going on in the courts and in the regulatory agencies, and work, as I said before, hand in hand with your legal counsel. So that's the sort of up-to-date EEOC report that I wanted to cover as we go into the summer, and there's so much activity going on the legal front. How about the U.S. Supreme Court? Well, when it comes to the U.S. Supreme Court, they've been kind of preoccupied with a lot of other issues, but one case has been decided during this term that I thought you should be aware of, and it has to do with the Fair Labor Standards Act. And it's a very important case that was decided by the Supreme Court during this term, and that has to do with the burden of proof on employers when they are trying to defend an exemption from the overtime and minimum wage regulations of the FLSA. So, as all of you know, this is constantly a challenge in classifying employees as exempt or non-exempt from overtime and minimum wage. Minimum wage really doesn't create that much challenge, at least in my practice, but the overtime issues do, especially with the pending regulations with regard to the salary caps. So the issue before the court was, what's the burden of proof on an employer when an employer is trying to establish in court that an employee is exempt under the Fair Labor Standards Act from overtime and minimum wage? Many, not all, but several of the U.S. courts of appeal have ruled that the burden of proof is higher than the normal burden of proof in a legal proceeding. Just to give you a quick legal lesson, if you will, the normal standard of proof in a legal case is something we call preponderance of the evidence, which in a jury instruction usually says that a certain proposition, a fact, is more true than not true. Okay? That's the preponderance of the evidence. And when an employee sues saying that they were misclassified, the preponderance of the evidence is a standard they have to show that they were misclassified. Some of the circuit courts of appeal had held that when the employer puts on its case to defend the classification, the employer has to prove the exemption by clear and convincing evidence, which is greater than a preponderance of the evidence, and thus a higher burden of proof to win the case or to establish the exemption. Well, the Supreme Court ruled in a case called EMD a couple of months ago that those courts of appeal were wrong, that the standard of proof for an employer to establish an exemption from the overtime and minimum wage provisions of the Fair Labor Standards Act is preponderance of the evidence. This clarified for employers that they don't have a higher burden than normal in a legal proceeding to defend themselves and try to establish an exemption from the minimum wage and overtime provisions of the Fair Labor Standards Act. This was an important decision in helping employers defend themselves against a misclassification suit brought by an employee. So this is something I thought you should be aware of. And for those of you who face this issue on a daily basis, you can take a little comfort that if you get into a legal challenge or when you're dealing with it with the Department of Labor, the legal standard is not a heightened one, as believed by some of the U.S. courts of appeals. Okay. One of the areas that we come across, especially for those of you in the public sector, is what's going on with the Office of Civil Rights. The Office of Civil Rights, which there are several among federal administrative agencies, but the one that we focus most on is the Office of Civil Rights in the Department of Health and Human Services. Here, under Kennedy's leadership, we are seeing three major developments which probably have a greater impact on public employers, but also private employers, and not so much in the employment context. So I'm not going to spend a lot of time on that. I prefer to talk about some of the other issues that you're facing. But I believe it's important to mention what's going on at the OCR. On the employment side, of course, the OCR also is at the same point as the EEOC, which is making sure that DEI initiatives are being addressed under the new administration's philosophy with regard to no DEI exception under Title VII or Title VI, which is administered by the OCR for recipients of federal funds and for educational institutions. And as you know from reading the news, this too is a judicial battleground, but nonetheless, the OCR is proceeding with its mandate to, for lack of a better term, end DEI initiatives over employers and institutions over which it has jurisdiction under Title VI. And other statutes that OCR gets involved with, either affirmatively or in processing complaints that are filed. The big action with OCR is on campuses and the OCR's and other multi-agency initiative against campus anti-Semitism. This is a big deal for the federal government, should be a big deal anyway. And as all of you know, some of the Ivy League schools are in battles with the federal government over withdrawal of funds and investigations of complaints about anti-Semitism. So there is a huge initiative. It's one of the priorities of OCR under HHS and the Department of Education to launch and implement this multi-agency initiative against anti-Semitism in the workplace, but especially on college campuses. So for those of you who are public employers, private employers, those of you in higher education, stay current on this because it's a big, serious initiative being undertaken by the federal government, much through OCR. The two other areas that might have an impact on employers pretty much are industry issues. As you know, Secretary Kennedy is a huge advocate for food safety. So we're seeing a lot of action by OCR and HHS in that regard, which will have some impact on employers and employment. We'll see how that plays out. Some of you may have already had experiences and are aware of this. The other initiative that OCR has undertaken is a bullying initiative. And so expect to see some complaints that are investigated with regard to bullying if OCR has jurisdiction over you, which is federal funds recipients and public entities, but anybody subject to Title VI of the 1964 Civil Rights Act. So there's activity there. And again, just like everything else in the federal government right now, everything's in a state of flux. But that doesn't, even though that's the case, and we don't know how all this is going to turn out completely in the courts, on a daily basis, we still have to deal with all this stuff. So again, stay in touch with your legal counsel, stay on top of the news, which I'm sure you do. But most importantly, make sure the news you're getting is accurate. Make sure that the cases you hear about, that you read those cases. Make sure that the news reports you get, you verify, because there is a lot of misleading information out there. And I have clients who call on a daily basis asking questions about all sorts of legal issues where they've gotten false or misleading information. Go to the primary source if you can, especially in this time in our country's history where things are so ambiguous. Okay, I talked about Trump's executive order. There isn't much more to say about that other than in employment, the executive order that had the most impact was the executive order that tries to eliminate DEI. And it's under the legal philosophy and legal position that any type of discrimination prohibited by Title VII is prohibited, and there are no exceptions. So that race discrimination, regardless if its purpose is diversity, is still illegal. And we're going to see a lot more of those cases brought in the courts. I'm seeing greater reports of those now being filed, but because it's early, it's going to be a year or two before we see the results of any of these, which is why I think you're going to get a greater insight into what the legal future holds by watching what's happening with regulations and the challenges against regulations, to see how the courts and administrative agencies are going to handle those during the Trump administration. But that's the big one. And of course, you know, it's up in the air and constantly being litigated. So again, pay close attention, but make sure the information you get is accurate, which is a challenge these days. All right, so let me switch gears a little bit and talk about, well, wait a minute. Before I do that, let's not leave the federal government just yet. A big part of my practice is traditional labor law. And I know that many of you deal with traditional labor law in the workplace. You have unions. You may not have unions, but you still may have interaction with the National Labor Relations Board, because as you know, as HR professionals, the National Labor Relations Act applies to employees whether they are organized or not. So on occasion, you will get unfair labor practice charges filed against employers, even though they don't have a union. So you need to be cognizant, even if your workplace is not organized, of what's going on under the National Labor Relations Act and with the National Labor Relations Board. Right now, it's a mess. 2 of the members have been removed by President Trump, and they have challenged their removal. 1 has lost. However, those battles are still in lower courts, not the Supreme Court. So right now, the NLRB is kind of in a state of flux. There's a big issue that's being litigated, although the courts, I don't think, are giving it a lot of traction, and that is the issue of the NLRB's jurisdiction. There have been, over the last 3 years probably, there have been some successful challenges in federal courts, federal trial courts, that the NLRB is not properly constituted under the law, and that it's the way it is constituted is unconstitutional. And that got traction in a couple of federal trial courts. It has not fared as well in the courts of appeal, but it's still percolating through the courts. So out here, sort of on the side of what the NLRB is doing, we have this issue about its jurisdiction. And has it had jurisdiction to render decisions? I don't think that's going to end up being a winner for employers, but it's out there, so you need to be cognizant of it. Again, it's not getting the attention it was getting a year ago, but it's still out there percolating through the courts. So we have that jurisdiction issue. We have, as I referred to a minute ago, litigation with the board members that President Trump removed from the board. As I indicated, one of them has lost her case in the appellate court. The other one is still in the trial court, to the best of my knowledge. But these issues are out there, and it is impeding the ability of the National Labor Relations Board to issue decisions. So that is serious. Also, if those terms either expire or the terminations are upheld, then President Trump will be able to appoint 2 members to the board. And the makeup is supposed to be 3 Republicans and 2 Democrats during a Republican president's administration. But the terms overlap, so sometimes that takes a while before you'll see some changes in board decisions. During Trump's first term, many changes were made in the board's decisions, precedent, and regulations. I would expect to see that again once Trump has a majority of board members. But I don't know, I can't predict how long that's going to take. So we can just watch and wait at this point. The other action that really is more impactful on us, on our day-to-day operations of taking care of the HR function, is how the board operates through its regional offices under the direction of its general counsel. Here, there has been a significant development. The acting general counsel, who took over probably 2 months ago, maybe a little earlier than that, issued a general counsel memorandum. To make a long story short, the general counsel, who runs the enforcement arm of the NLRB and determines policy for all the regional offices and how they enforce the law, issues guidelines through what are called general counsel memoranda. And the prior general counsel was very, very aggressive on the pro-employee and pro-union side. In fact, those of us who are management attorneys were pulling our hair out over some of the what we considered to be extreme positions that she took in enforcing the labor board, especially when it came to draconian remedies against employers. So she had a series of general counsel memoranda that directed the regional officers on how to enforce the law. And honestly, from my standpoint as a management attorney, she was way over the line, especially again in terms of remedies, but also in application and interpretation of the law. But that, of course, is subject to debate. And a lot of what she did was challenged in the courts. Some of it was upheld, some of it was not, because the way that works is on a case-by-case basis. Although the NLRB does make regulations with regard to elections and other types of procedural things, those regulations were in various stages of being challenged. But when the new acting general counsel took over, he issued a memorandum. It's probably been, I meant to write the date down, but it's probably been 2 months ago, rescinding almost every single general counsel memorandum that Jennifer Abruzio, who was the prior general counsel, had issued. So we are, based upon the general counsel's office and how it's going to administer the law through its regional offices, when it comes to the enforcement of the National Labor Relations Act, we are now at a point where we're sort of back to pre-Biden era status. Now, because it's been so recent, and I am seeing it play out in the cases I have before the NLRB, there are certain things they don't ask anymore that they used to ask. There are certain positions they don't take anymore that they used to take in unfair labor practice charges. So it is having some effect, but it's very much TBD on how things are going to go forward in the future. And then since the board itself is not issuing decisions, we're really up in the air on labor law right now. But we still have to deal with unfair labor practices and elections and other enforcement and compliance issues that come up with the NLRB. And those are the day-to-day challenges we have, regardless of what's happening in the courts and on the national level. And I have to say, at least for Region 14, which is the region I deal with most of the time, which covers the St. Louis metropolitan area, they are exercising caution. They're being reasonable, at least in my cases, and we're moving slowly as we navigate our way through this new environment. So, I mean, some people, it's kind of hard for some people to just kind of realize that we've only been, 4 months into the new administration. So things are a little chaotic, and they're going to be that way for a while. But we still have to deal with these issues on a daily basis. And insofar as my interaction, my colleagues' interaction with the NLRB has been at the local level or at the regional level, things are running fairly smoothly as we try to navigate our way through all this uncertainty. So that's what's going on with the NLRB. The big issue was the rescission of all these general counsel memoranda, and we're kind of back to pre-Biden era general counsel memoranda and the way that the regions are going to enforce the statute. So we'll see. All right. That's a pretty good 30 minutes on what's going on in the federal level, and it doesn't cover everything. I'd need all day, which you wouldn't want to sit through, to go through everything going on. But let's turn to what's going on the state levels, the level of the states, I mean. So here's what we're seeing. And Illinois is a pretty good example of what we're seeing a lot of states doing in the labor and employment law field. Illinois considers itself to be a progressive state. I'm not sure that employers in Illinois would agree that it's progressing or that it's progressive, but politically it's a progressive state. So we see a lot of noodling by the General Assembly. And when I say noodling, this is from the point of view of employers, making it increasingly difficult to do business in Illinois because of the regulatory atmosphere and the constant meddling of the General Assembly in your affairs, in trying to conduct your business, make a profit, and be fair to your employees. So to start off, there is an Illinois Supreme Court decision which will be of interest to Illinois employers. And that is a case that was decided by the Illinois Supreme Court recently, in which the issue was when you're calculating overtime pay and you have to determine what the employee's regular pay is. You know how that works. You got to determine overtime pay. To do that, you have to determine the employee's regular pay. So the issue in this case was whether or not performance bonuses were to be considered in determining the hourly wage of an employee. Performance bonuses are discretionary. I mean, they are related to, hopefully, attainable goals by employees, but they're not bonuses that are automatic. Okay. So the argument the employer made was, look, those are sort of like non-discretionary bonuses. And so they should not be added into the calculation of the hourly rate for overtime purposes. Well, the Illinois Supreme Court decided that under Illinois statutes, that performance bonuses were to be considered in calculating the hourly rate of an employee for overtime purposes. So if you weren't already aware of that, those of you who work and have companies that do business in Illinois, you need to be aware of that now in determining the overtime rate for an employee, if that employee has received performance bonuses in the applicable year of pay or quarter or whatever, that has to be calculated into the hourly rate for overtime purposes. So big development here in Illinois. That, of course, will lead to increased overtime payments for employees who get performance bonuses. All right. So that's the one court decision I wanted to talk to you about. Now, as I indicated earlier, artificial intelligence is a big issue, not just on the federal level, but also on the state level. So Illinois is no exception. And Illinois enacted a statute that addresses artificial intelligence in a number of areas. But one of those was employment. And it is now illegal in Illinois to discriminate on the basis of the use of artificial intelligence. Again, the target is mostly in the selection process, but the statute is broader than that. You cannot use AI to discriminate, or if AI discriminates, whether you intend it to or not, it's a violation of the Illinois Human Rights Act. This is not something unique to Illinois. As we discussed, the federal government has undertaken the same approach through the EEOC, but Illinois has done the same thing by statute, and it will be administered by the Illinois Human Rights Department and the Illinois Human Rights Commission. So be aware, and I'm sure you already are, that AI is a minefield, a legal minefield in human resources. So that's one thing that is an important aspect of what Illinois is doing. What else are we seeing? Well, before Trump got elected, the federal government went on the National Labor Relations Board enacted a policy of no captive audience meetings. Those of you who are familiar with collective bargaining know that employers were permitted in the past to require employees to come to a meeting where the employer gives its opinion, and truth and facts have to be true about collective bargaining during an organizational campaign. Well, the NLRB, before the election, promulgated a rule that did away with captive audience so that employers could no longer do that. Well, at the same time, because Illinois was afraid that the feds were not going to do it, it enacted what was called the Worker Freedom of Speech Act, which took effect January 1st. And it does the same thing. It says that employers cannot force employees without their consent, which of course is forcing them, to attend meetings where the employer gives its opinion about whether it's really anything, pretty much, not just labor relations. In fact, the statute says opinions about religious matters or political matters, in elections, political parties, legislation, and labor organizations, of course. So even though I don't think that the NLRB, once it's constituted the way President Trump wants it, is going to enforce that captive audience regulation, keep in mind that your state, and certainly Illinois, may have a statute that outlaws these anyway. So be alert to that. In Illinois, it's called the Worker Freedom of Speech Act. So no more captive audience for Illinois employers. Now, of course, that's been challenged in court, and it's pending in the courts. It's been challenged on two bases. One, First Amendment violation of employers, and two, that it's preempted by the National Labor Relations Act. Again, we'll see how it goes. But in the meantime, we have to follow it. Another very popular statute that was enacted by Illinois and has become very popular in about half the states, and we're seeing it being enacted in other states more often, is what is called the Pay Scale and Benefits statute. This one I know you're familiar with because it's been in effect since January 1, and you're doing it. And that is where we have to post the pay scales and the benefits when a job is posted. And there's a lot more to it than that, but the gravamen of the statute is that when we post a position, the candidates or applicants have to be aware of the pay scale and benefits for any position in a job posting after January 1st of this year. So, and if you use a third party, like higher level, that also, the statute still applies. So I have had, none of my clients have had a problem complying with this. They don't all like it, but complying with it is fairly easy. And as I said, this is a trend nationally. So wherever you do business, you need to be on the lookout for this, because it's something that has gained a lot of popularity, and also, quite honestly, on its face seems reasonable. Did I say that out loud? Okay, so that's the pay scale and benefits posting. All right, so a couple of other trends we're seeing across the country and manifesting itself here in Illinois are several changes to the Human Rights Act, additions primarily, one of which is family responsibility discrimination. And again, this is becoming more popular across the country. What is family responsibility discrimination? Well, it's discrimination that's illegal under state law for an employer to take an adverse employment action against an employee based upon the employee's family responsibilities. That, of course, begs the question, what is a family responsibility? And it's defined in our statute as an employee's actual or perceived provision of personal care to a family member. So, and a family member is broadly defined pretty much as the immediate family, but, you know, including steps and in-laws. And how this is going to, we're still waiting for regulations on this. But you should know that in our statute, an employer is not obligated to accommodate or modify reasonable workplace rules based upon this new protection. Nor is an employer prohibited from taking an adverse action or otherwise enforcing reasonable workplace policies against an employee as long as they don't otherwise violate the Illinois Human Rights Act. Now, if there's ever an invitation for litigation, this statute is it. It's ambiguous, it's broad, and hopefully when the Illinois Department of Human Rights issues regulations, we'll have more clarity. But this is going to be just a gift to labor and employment attorneys in the state of Illinois. Okay. Well, we're running out of time as always. Personnel Record Review Act in Illinois, as in many states, we have a law that allows employees to look at their personnel records, get copies of them, and you can't have anything in there that to use against them if they don't know about it. So because of our time limitation, I would suggest that if you haven't already looked at the amendments to the Personnel Record Review Act, that you do. It includes, of course, personnel documents, contracts, handbooks are now subject to production under the Personnel Record Review Act, procedures, policies, and so it's been broadened, and also it's easier for employees to get the information. I know a lot of you have experience with this, especially because we get plaintiffs' attorneys, unions, asking for information on behalf of employees all the time. We're used to doing this, but just keep in mind, you need to look at the amendments because it's broader and it's easier for employees to get access. Okay, one thing I wanted to mention in the last few minutes that we have is a new provision to the Illinois Human Rights Act, which again reflects national trends, and that is discrimination on the basis of reproductive health decisions. So let me tell you a little bit about that. Illinois has enacted a provision to the Human Rights Act to provide protection in employment from discrimination based upon reproductive health decisions. And that goes way beyond abortion and pregnancy. Pregnancy under Illinois law is already specially protected. But this goes to protect discrimination based upon fertility, adoption, just about any contraception, just about any reproductive health decision you can imagine is protected under the Illinois statute. So I don't know what the cases here are going to look like, but keep in mind that as Illinois, as part of this national trend, has given employment protection, employment discrimination protection to employees from being discriminated against based upon reproductive health decisions of which the employer might become aware or which have an impact on the employee's ability to require accommodations or other types of employment issues that arise. So keep in mind, because this is a national trend. The statute, again, I think it's going to be fleshed out through regulation, I hope, because there's a tendency in these statutes to use broad terms that are subject to interpretation and which then lead to greater litigation and expense for employers. So we need to be sensitive and careful about this. And especially stay up to date and get good primary information about these things. And again, as I've said a million times, work hand in hand with your legal counsel to navigate these minefields. Okay. We have 5 minutes left. I wanted to see if anybody had any questions. Summer, have we got anything?
John, I don't see that we have any questions at the moment, but since you did open it up, I will give people just a few moments to jump in and ask those. I did have a question over the overtime rates.
Mm-hmm.
Now, those bonuses, do they look at a bonus within like the pay period, or do they look at the entire year? Where do they look at for those bonuses?
I'm sorry to interrupt. In this case, it was the year.
Okay.
So this guy got a performance bonus, and to determine his annual rate for overtime, they added that in there. Good question.
All right. I don't see any other questions coming in today. As always, thank you for your time. A lot of really
thank you, Jill Turner.
There's a question. There is a question, but it's yes, I am going to be sending the presentation out there as a recording, and we will be sending this out along with the continuing education credits that will be available. So thank you all for joining, and we will see you next month.
Thank you, Summer.
Have a great day.
Bye-bye.